You're convicted in state court, life in prison, you appeal, you lose. Years later, you discover the prosecution hid evidence that could have helped you, evidence that contradicted a key witness. You file for a new trial in state court. The lower state court grants it, but the state appeals court reverses. They say even if the hidden evidence totally destroyed the witness's credibility, the other evidence against you was so strong you still would have been convicted. No reasonable probability of a different result. You take it to federal court, habeas corpus. The federal district court says you deserve a new trial. The federal appeals court agrees. But on January 26, 2026, the Supreme Court reversed, 8-1. The case is Klein versus Martin, and it just reinforced that federal courts must give state court decisions the benefit of the doubt under AEDPA, even when federal judges think the state court got it wrong, even when federal judges would have decided differently. This affects every state prisoner seeking federal habeas relief, every Brady claim, every challenge to withheld evidence. Because the Supreme Court just told federal courts, your job is not to retry the case. Your job is to defer to the state court unless their decision was unreasonable. And unreasonable doesn't mean wrong, it means extreme. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is how the Supreme Court just made it even harder to get federal habeas relief when state courts deny your claims. This decision affects thousands of prisoners who think federal courts will save them when state courts won't. Hit that subscribe button right now, because if you don't understand AEDPA deference and Brady materiality, you could miss your only shot. Here's what happened in this case and why every detail matters. Charles Brandon Martin was dating Jody Torok. She got pregnant. She thought Martin was the father. Martin demanded she get an abortion. She refused. She told him she was going to court to get child support. A few weeks later, someone knocked on Torok's door while she was home alone, a man posing as a salesman. Torok was on the phone with a friend. She hung up to talk to the man. She told her friend she'd call back. She never did. Her friend called repeatedly. No answer. The roommate found Torok on the floor, unconscious, bleeding from a gunshot wound to the head. She survived. Police investigated. They found a shell casing and bullet, .380 caliber. They found a modified Gatorade bottle. It appeared to be a homemade silencer. There was tape on the bottle. A hair was stuck to the tape. Forensic analysis showed the hair could not have come from Torok, but it was microscopically similar to Martin's hair. The state argued Martin made the silencer. Federal firearms records showed Martin owned a .380 caliber semi-automatic handgun, the type that could have fired the bullet. Witnesses testified Martin had access to materials to make a silencer. One witness, Monique Carter, was Martin's girlfriend. She testified that Martin kept a laptop at her apartment. She said she saw Martin using the laptop to research gun silencers shortly before the shooting. She said after the shooting, Martin took the laptop and got rid of it. He didn't want it found if police searched her apartment. At trial, Martin was convicted as an accessory before the fact. The jury found he aided or encouraged the attempted murder. He was sentenced to life in prison. His conviction was affirmed on appeal. Martin then sought post-conviction relief in Maryland State Court. He argued the prosecution violated Brady versus Maryland. Brady says the government must disclose evidence that's favorable to the defense. Martin said the state failed to disclose a forensic report about computers seized from his home. Police had seized 5 computers. One was a laptop issued to Martin by a former employer. The forensic report analyzed that laptop. The report found no evidence the laptop had been used since 2005. The shooting was in 2013, 8 years later. The report also noted that keyword searches for words like handgun, silencer, and homemade silencer yielded no hits. Martin argued this laptop was the one Carter testified about, and the report contradicted her testimony. She said Martin used the laptop to research silencers. The report said the laptop hadn't been used in 8 years and had no searches for silencers. The Maryland Post-Conviction Court agreed with Martin. The court ordered a new trial, but the state appealed. A unanimous panel of the Maryland Court of Special Appeals reversed. The court acknowledged the forensic report was favorable to Martin. It could have impeached Carter's testimony. But the court said the report was not material under Brady. Why? Because even if the report totally discredited Carter, the other evidence against Martin was so strong that there was no reasonable probability the trial result would have been different. The DNA evidence, the gun ownership, the motive, the circumstantial evidence, all of it pointed to Martin. Carter's testimony was just one piece. Even without it, Martin would have been convicted. The Maryland Court of Appeals denied review. Martin appealed to the U.S. Supreme Court. The Supreme Court denied certiorari. Martin then filed for federal habeas relief. He argued the Maryland court's decision was an unreasonable application of Brady. The federal district court agreed. The court granted Martin's habeas petition. The court ordered a new trial. The state appealed to the Fourth Circuit. A divided panel of the Fourth Circuit affirmed. The majority acknowledged that the Maryland court had correctly stated the Brady materiality rule. but the majority said the Maryland court didn't actually apply that rule. The Fourth Circuit said the Maryland court applied the wrong test. Instead of asking about a reasonable probability of a different result, the Maryland court asked whether the remaining evidence was sufficient to convict. That's the sufficiency of the evidence test. And the Supreme Court has said that's not the right test for Brady materiality. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down common mistakes federal courts make. Reviewing state court decisions under AEDPA is complex, and the Supreme Court keeps slapping them down. Subscribe right now so you don't miss it. The state appealed to the Supreme Court. And on January 26, 2026, the court issued a per curiam opinion. That means unsigned. The whole court. The court reversed the Fourth Circuit, 8-1. Only Justice Ketanji Brown Jackson dissented. And she didn't write an opinion. She just noted she would have denied certiorari, meaning she wouldn't have taken the case. The court's opinion was scathing. The court said the Fourth Circuit departed from what AEDPA prescribes. AEDPA is the Antiterrorism and the Effective Death Penalty Act of 1996. It sets strict standards for federal habeas relief. Under AEDPA, a federal court can only grant habeas relief if the state court decision was contrary, or if it involved an unreasonable application of clearly established federal law, or if the decision was based on an unreasonable determination of the facts. That's a high bar. Unreasonable doesn't mean wrong. It means no fair-minded jurist could agree with the state court's conclusion. The Supreme Court said the Fourth Circuit violated this standard in two ways. First, the Fourth Circuit second-guessed the state court's factual findings. The Fourth Circuit said the state court didn't exhaustively examine the suppressed evidence or provide a nuanced analysis of the impact. But the Supreme Court said that's not the federal court's job. AEDPA doesn't require state courts to write detailed opinions. State courts don't have to address every piece of evidence. Federal courts have no authority to impose opinion-writing standards on state courts. What matters is whether the state court's decision was unreasonable, not whether it was as detailed as the federal court would have liked. Second, the Fourth Circuit misapplied the Brady materiality standard. It said the Maryland court used a sufficiency test instead of the reasonable probability test. But the Supreme Court said that's not what the record shows. The Maryland court explicitly stated the correct test, reasonable probability of a different result, and the Maryland court applied that test. The court reviewed all the evidence and concluded there was no reasonable probability of a different result. That's the right analysis. That's what Brady requires. The Fourth Circuit was wrong to say otherwise. Now, a quick legal note. This is educational information, not legal advice. If you're a state prisoner seeking federal habeas relief, consult with an attorney. Well, AEDPA is complex. Every case depends on specific facts. Get professional counsel. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 people who understand how federal courts review state convictions and what that means for your rights. Click subscribe. Now let's talk about what Brady materiality actually requires. Brady versus Maryland is a 1963 Supreme Court case. It established that the prosecution must disclose evidence that's favorable to the defense. This includes exculpatory evidence, evidence that tends to prove innocence, and impeachment evidence, evidence that discredits prosecution witnesses. But not all favorable evidence has to be disclosed, only material evidence. Material means there's a reasonable probability that disclosing the evidence would have changed the trial outcome. Reasonable probability means a probability sufficient to undermine confidence in the verdict. It's less than more likely than not, but it's more than just possible. The question is, if the jury had heard this evidence, is there a reasonable probability of a different verdict? To answer that, courts look at the totality of the evidence, not just the withheld evidence in isolation. In Martin's case, the withheld evidence was the forensic report. It contradicted Carter's testimony about the laptop. But Carter's testimony was just one piece of evidence. There was DNA evidence linking Martin to the silencer. There was evidence Martin owned the right type of gun. There was motive evidence. Torok was pregnant and threatening child support. There was circumstantial evidence placing Martin near the scene. The Maryland court looked at all of this. The court concluded that even if the forensic report destroyed Carter's credibility, the other evidence was overwhelming. A jury would still have convicted. Therefore, the forensic report was not material. There was no reasonable probability of a different result. The Supreme Court said this analysis was correct. It was not unreasonable. A fair-minded jurist could easily reach that conclusion. Let me give you examples. Example 1. The prosecution withholds DNA evidence that shows someone else committed the murder, and the only evidence against the defendant is eyewitness testimony. Is the DNA material? Yes, obviously. Example 2. The prosecution withholds evidence that a key witness was paid for their testimony. Is the payment information material? Probably yes. Impeaching the key witness could undermine confidence in the verdict. Example 3. The prosecution withholds evidence that contradicts one witness's testimony, but there are 10 other witnesses who say the same thing. and there's physical evidence corroborating all of them. Is the contradiction material? Probably not. Even if you completely discredit one witness, the other 9 plus the physical evidence would still support the verdict. That's the situation in Martin's case. Carter was one witness. The forensic report contradicted her, but there was a mountain of other evidence. DNA, gun ownership, motive. Even without Carter, Martin would have been convicted. This information could literally determine whether you get a new trial or spend the rest of your life in prison based on withheld evidence. Subscribe now because my next video explains exactly how to frame a Brady claim to maximize your chances under AEDPA's strict deference standard. Hit that subscribe button. Now let's talk about what AEDPA deference actually means. AEDPA was passed in 1996, after the Oklahoma City bombing. Congress wanted to limit federal habeas review of state court convictions. The law creates 2 main barriers. First, exhaustion. You have to exhaust your claims in state court before going to federal court. You can't just skip state court and go straight to federal habeas. Second, deference. Even after you exhaust, federal courts must defer to state court decisions. Under Section 2254D, a federal court can only grant relief. If the state court decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court. Contrary to means the state court applied the wrong rule, or reached the opposite conclusion on materially indistinguishable facts. Unreasonable application means the state court identified the correct rule but applied it unreasonably to the facts. Unreasonable doesn't mean wrong, it means objectively unreasonable. No fair-minded jurist could agree with the state court. This is a very high bar. It's designed to give state courts the final word in most cases. Federal courts are not supposed to retry cases. They're supposed to correct extreme malfunctions. In Martin's case, the Maryland court applied the right rule, reasonable probability of a different result, and the court's application was not objectively unreasonable. A fair-minded jurist could conclude the forensic report wouldn't have changed the verdict. Therefore, AEDPA barred habeas relief. The Fourth Circuit went wrong by imposing its own judgment. The Fourth Circuit thought the state court should have analyzed the evidence more carefully, should have written a more detailed opinion, should have considered the evidence differently, but that's not the Fourth Circuit's call. The state court's decision wasn't unreasonable. It was within the range of reasonable disagreement. AEDPA requires federal courts to give state courts the benefit of the doubt in those situations. Look, I spend hours every week reading Supreme Court habeas decisions, tracking how AEDPA deference works in practice, and analyzing why federal courts keep getting reversed for failing to defer enough to state courts. Subscribe to make sure you never miss this information. Subscribe right now. If you found this helpful, share it with anyone interested in criminal procedure because AEDPA deference is a misunderstood doctrine. Now let's talk about the practical implications. If you're a state prisoner with a Brady claim, here's what you need to know. First, exhaust your claim in state court. File in trial court. Appeal to the highest state court. Don't skip steps. If you don't exhaust, federal courts can't hear your claim. Second, frame your claim correctly in state court. Argue that the withheld evidence was material under Brady. Show how it would have changed the trial outcome. Prove it was material. Third, understand that winning in state court is your best bet. If you lose in state court, federal habeas is an uphill battle. AEDPA deference means federal courts will usually side with the state court. Fourth, analyze whether the decision was objectively unreasonable, not just wrong, unreasonable. Could a fair-minded jurist agree with the state court? If yes, you lose under AEDPA. Fifth, don't expect federal courts to give you a second bite at the apple. Federal habeas is not an appeal. It's a limited safety valve for extreme cases. And sixth, hire an attorney who understands AEDPA. This is specialized litigation. Now let's talk about why Justice Jackson dissented. Jackson didn't write an opinion. She just noted she would have denied certiorari, meaning she wouldn't have taken the case. Why? We can only speculate. Maybe Jackson thought the Fourth Circuit's decision was defensible. Maybe she thought the case didn't warrant summary reversal. Summary reversal means deciding the case without full briefing or oral argument. It's reserved for clear errors. Maybe Jackson thought this wasn't a clear error. Or maybe Jackson has concerns about AEDPA deference generally. She hasn't written extensively on this topic yet. But her dissent suggests she might be more sympathetic to habeas petitioners than some of her colleagues. We'll have to wait for future cases to see if a pattern emerges. Now let's address criticisms of this decision. Some argue AEDPA deference is too strict. It allows state courts to get away with unreasonable decisions, as long as a fair-minded jurist could possibly agree. That means even clearly wrong decisions can stand. Critics say this undermines federal court review. It makes federal habeas meaningless. If federal courts always defer, what's the point? But supporters of AEDPA say it respects federalism. State courts are competent. They can decide constitutional questions. Federal courts shouldn't micromanage them. And Congress has the authority to set the standards. AEDPA is the law. Federal courts have to follow it. The Supreme Court has consistently enforced strict AEDPA deference. Klein versus Martin is just the latest example. This term alone, the court has reversed 2 Fourth Circuit decisions for failing to defer enough. The message is clear. Federal courts must give state courts the benefit of the doubt, even when federal judges disagree. Remember, this is educational information based on the Supreme Court's per curiam decision in Klein versus Martin, decided January 26, 2026. It is not legal advice for your specific situation. If you're seeking federal habeas relief, consult with a qualified habeas attorney. Every case is unique. Get professional counsel. Stay informed. Know your rights. And understand that AEDPA deference is real. Federal courts can't save you just because they think the state court was wrong. The state court decision has to be objectively unreasonable. And that's a very high bar. If you're Charles Brandon Martin, serving life in prison, this decision means you're staying there. The Supreme Court said the evidence against you was overwhelming. Even without the laptop testimony, you would have been convicted. The forensic report wouldn't have changed that. 8 justices agreed. And under AEDPA, that's the end of the road. Subscribe so you understand how these standards apply when your freedom is on the line.